Hello, this is Murray Coleman, broker with Keller Williams here in Florida. Today we're going to look at the vacant land contract, or the VAC 14. You will find it useful to have the handout called the 83 Spaces of the Vacant Land Contract handy. This handout can be found in the Files section of the Broker Forum on Facebook. If you're familiar with the FAR 6 and the as-is, you're going to notice many similarities in wording, but there are some major differences which you will need to be aware of. The terminology is somewhat different, and as we go through the presentation, I'll highlight them for you. Vacant land means a legally identifiable piece of the United States which does not have any current habitable buildings standing on it. If the property has a viable living structure which the buyer intends to use, the residential contract may be more suited for the transaction. We do sell land with old trailers, barns, stables, and outbuildings, and the VAC 14 is a suitable contract for that. Prior to getting into the paragraphs of the contract, I just want to talk to you about the computation of time, because it is quite different from the FAR 6 and the as-is. Paragraph 11 defines time periods and how they're computed in this contract. And I want you to note the differences with the residential contract. Time periods are calendar days, which means that every day of the year is counted, except for time periods of 5 days or less. When the period is 5 days or less, Saturday, Sunday, or national legal holidays are not counted. Much like the residential contract, for periods over 5 days, all days are counted. And if the final day is a weekend or legal holiday, it extends to 5 p.m. on the next business day. And the recent change on the residential contract made it from 5 p.m. until midnight. So just be aware that when this one jumps from a weekend or holiday, it jumps to 5 p.m., much like the old residential contract. Time for acceptance and the effective date are not included in the above computations. They can end on any day. And in big bold print at line 238, we see the famous phrase, time is of the essence in this contract. And now we'll go to paragraph 1. Paragraph 1 names the buyer and seller. Please refer to the 83 Spaces handout to see examples of how to write the name if it's an LLC, a trust, or an other entity, and then identify who will sign on behalf of those entities and how the signature should be framed. The address is fairly straightforward. The legal description can be quite lengthy because of land contracts. Consider using the additional terms or use a blank exhibit sheet if it doesn't fit on those lines. You'll see the terms on line 11, section, township, and range of whichever county in Florida it is with the PID number. And that includes all improvements existing on the property and any following additional property. So if there is a barn structure that is not fixed to the ground, then that would be identified here on line 12. There's a good article in Florida Realtors, which I put the link on this presentation and in the accompanying handout, which talks about an app called Land Glide. It's worth checking out because you can look at any piece of property in Florida and find the section, township, and range. And you can also find out where the property lines are. If you don't have that app, you can go to the property appraiser's website and find the section, township, and range. It's normally the first 6 numbers of the PID. Paragraph 2 The purchase price and the escrow agent. Make sure that the full information of the escrow agent is on there. Fill out every blank. It's a state law. If you're unable to ascertain where the seller wants the deposit to be sent, consider placing it with your own attorney or title agent to be transferred to the closing agent at a later date. Section 2A to 2E are similar to the residential contracts, but take a look at 2F on line 32. This is very different. In this subsection, the buyer would be offering a price per acre or for the lot or for the square foot. So for example, they may be making an offer at $300 per square foot or $300,000 per acre, and 2F would be used in those circumstances. Paragraph 3 talks about time for acceptance and the effective date. The time for acceptance provides for an automatic withdrawal of offer by the buyer once that date elapses. If the seller wishes to accept the offer outside of that date, on line 39, it should be amended and presented back to the buyer for their initials. For further information on this particular subject, take a look at my video and notes in the broker forum, or also on the YouTube channel. There is also a great article in floridarealtors.org covering the same material. The effective date is day 0 and is the date on which the last one of the seller and buyer has signed or initialed and delivered the offer or final counter offer. And just note the difference with counter offers in the land contract is 3 days. In the residential contract, it's 2 days. Paragraph 4, the closing date. This is the date when they close, regardless of any time period which extends beyond the closing date. So for example, if the closing date is June the 6th and the due diligence period extends beyond June the 6th, the closing date will prevail. This section also reiterates the process of skipping to the next business day when the closing gets scheduled or extends to a weekend or public holiday. There is also a type of force majeure provision in this paragraph which states if the ability to obtain insurance is suspended at the property location, the closing can be extended up to 5 days after the suspension is lifted. Another unrelated provision as a last line has been snuck in here, stating that any seller-provided documents, plans, etc. are to be returned to the seller if the buyer doesn't close. Paragraph 5. It's very similar to paragraph 5 of the residential contract. There is a CFPB extension if it's a finance transaction for the buyer to review the CD on finance deals. This period does not exceed 10 days. However, the residential contract was recently changed to 7 days. Paragraph 6, financing. 6A indicates that the buyer will pay cash for the property with no financing contingency, and 6B covers finance purchases with a default of 30 days for loan commitment period. We know from the residential contract that the word commitment was removed, as a lender cannot truly give commitment until the moment the buyer signs the closing documents. The land contract also mentions approvals as a catch-all. The loan application must be made within 5 days, and the buyer has an obligation to provide the lender with credit, employment, financial, and other information required by the lender. Buyers must use diligence and exercise good effort to obtain the financing within the financing contingency period. And if they do not get the loan, either party may terminate and the deposit is returned. The residential contract is very different. The seller can only cancel if the buyer does not provide the required notices at the end of the loan approval period, and in that contract they have 3 days in which to cancel the contract and return the deposit to the buyer. And obviously that doesn't appear in this contract. 6B1 covers new financing, and the terms and scope of the loan is declared. It also gives permission for the seller and the agent to make inquiries about the progress of the loan with the seller. 6B2. Seller financing. Our role is minimal, but it gives the seller the responsibility of providing written notice to the buyer of whether or not they will make the loan to the buyer within 10 days of the effective date. In 6B3, it talks about assuming a mortgage. And obviously, when we deal with a transaction where the seller and buyer are going to undertake a seller financed or assumption, the parties will seek professional advice from their lawyer and or an accountant. Paragraph 7, much like the residential contract, asks the assignability questions. Paragraph 8 deals with title. The preference is to convey by statutory warranty deed. However, a special warranty deed may be requested by the seller. In Florida, a special warranty deed is a real estate transaction in which the transfer of property is involved. It is often more limiting than other kinds of real estate deeds because the special warranty deed allows the seller or the grantor to turn over the deed of the property in any condition that he or she received it. The seller must provide a warranty that no damage or defect has occurred while he or she owned it, but does not make any guarantees against what might have occurred to the property before he or she came to own it. A special warranty deed in Florida is often used by a lender when they acquire a new property through foreclosure. When the lender then sells or grants the property to developers or new buyers, the lender is required to ensure there are no defects to the property during the lender's ownership. However, the lender is not held accountable for any problems to the property that occurred before the foreclosure gave the lender title. Essentially, the lender or seller of the property is saying that he or she is granting the property to a new owner in exactly the same condition as it was received. Talk to a real estate attorney or a foreclosure expert before entering into a special warranty deed in Florida. You want to make sure that all your claims to the property are protected, especially when you're dealing with a foreclosed property. 8A at line 101 is title evidence. The party who pays for the owner's title insurance policy will select the closing agent and pay for the title search, including tax and a lien search, and all other fees that are charged by the closing agent. There are boxes and blanks to make the selection in the contract and state when the search will be completed by and the title commitment given. The parties can either select a title insurance commitment at 8A1 if the buyer is paying for the owner's title insurance and the seller has an owner's policy. The seller will deliver a copy within 15 days of the effective date. Or they can select 8A2, which is an abstract of title. This is a summary of all the recorded instruments that may affect title. They can go back many years, and they state all the mortgages, liens, judgments, etc. that may affect the title. An attorney will normally study the abstract and give an opinion on the security of the title. There have been cases where there have been omissions and forgeries, but generally provide a sound historic record if such an abstract is not available. Paragraph 8B, after receipt of title evidence, the buyer shall, within 10 days it defaults to, but no later than closing date, deliver written notice to the seller of any title defects that have been discovered. Again, very, very similar to the residential contract. Title will be deemed acceptable if the buyer fails to give notice. So that's a very key date for you to remember. Or, buyer delivers notice, a seller cures the defect within X number of days, and the default is 30. This is known as the cure period, the 30 days. Once the defects are cured, the closing will take place within 10 days of the seller providing the buyer with such notice of cure. Seller may elect not to cure defects if the seller reasonably believes the defect cannot be cured during the period. The buyer will then have 10 days from the notice to decide whether they will accept it with the defects and there will be no price reduction, or they can terminate the contract. Paragraph 8C at line 128 talks about the survey. At the buyer's expense, they can conduct a survey and must deliver written notice to the seller within 5 days of receiving the survey, but no later than 5 days prior to closing, identifying encroachments on the property, encroachments by the property to another property, deed restrictions, or zoning violations. And survey defects will be treated exactly the same as title defects are in 8B above. Paragraph 8D simply states that the seller warrants that the property has ingress and egress. That's entry and exit. Paragraph 9, property condition, inspections, and due diligence. Due diligence is another term for the inspection period. There is no standard form contract or as is. The vacant land contract has a due diligence period where the buyer may inspect and may cancel within the period at the buyer's sole discretion if they determine the property is not suitable for the buyer's intended use. The property has got to be maintained by the seller in its present as-is condition as of the time of acceptance. The seller may not engage in any activity that would materially alter the property's condition without the buyer's written consent. For example, cut down trees, plough the land, plant corn, whatever people with land do. So the buyer must check either box 9A1 or 9A2. This is the buyer's election whether or not they want to conduct due diligence or to waive it. During the due diligence period, the buyer may conduct a Phase 1 environmental assessment to identify potential environmental risks to the property, such as current or historic operations that are known or suspected to have caused hazardous substances or petroleum products during on-site operations. Some very common uses of concern are dry cleaners, gas stations, auto vehicle repair shops, printing operations, and manufacturing. In addition to potential soil and groundwater contamination, the buyer may also conduct other tests, analysis, surveys, lists them all in the contract, or other investigations in the buyer's opinion are necessary to determine if the property's engineering, architectural, or environmental properties or zoning restrictions, subdivision statutes, soil and grade, availability of access to public roads, water, and other utilities, consistency with the local, state, and regional growth management plans, availability of permits, governmental approval and licenses, and other inspections that the buyer deems appropriate. That is quite the list. If the property must be rezoned, buyer will obtain the rezoning from the appropriate government agency. And the seller is obligated to sign all documents the buyer is required to file for rezoning and development approvals. Seller gives buyers, agents, inspectors, contractors, etc. the right to enter the property during the due diligence period. They enter at their own risk, and this contains a hold harmless for the seller. The buyer cannot and will not engage in any activity that would result in a construction lien being placed on the property without the seller's prior written consent. If the property doesn't close, the buyer will repair all damage and release all reports and other work done during the inspections. Prior to the end of the due diligence period, the buyer must deliver written notice of whether the property is acceptable or not. If they do not give notice, the buyer shall have deemed to have accepted the property in its as-is condition. If the notice states that it's unacceptable, the contract terminates and the buyer is refunded their deposits. Paragraph 9A2, if checked, states that the buyer accepts the property is suitable without the need for further inspections and there is no further contingency. Paragraph 9B, government regulations. If there is a change in the law or regulations that will affect the property and the due diligence period has expired or was waived, it will not be grounds to terminate the contract. Paragraph 9C talks about flood zones. The buyer is advised to research the availability of insurance and flood risk and what impact of the flood would have on the property. Paragraph 9D talks about the coastal construction control line. And in the handout, I've put a link to floridadepartment.gov where you can see where the coastal control lines are. It provides that if any of the part of the property is seaward of the line, the seller will provide an affidavit or survey showing the line, and the buyer may waive this right by checking the box on the contract at line 185. It's important to know where these coastal lines are due to erosion and possible implications to marine life preservation. Paragraph 10, closing procedures. Closing will take place in the county where the property is located, but may be conducted by electronic or mail away. This section gives instructions to the closer that as long as title insurance is bound, they do not have to wait for the deed to be recorded to release the proceeds and broker commissions, provided the seller makes a written request at least 5 days before closing. 9A describes the seller cost, and 9B, the buyer's costs. Then in 9C talks about prorations, and then the following items will be made current and prorated as of the day before closing. The buyer will own the closing day. So the following items are real estate taxes, special benefit taxes imposed by a CDD, interest, bonds, assessment, leases, and other property-related expenses and revenues. If tax is not known for the current year, they will adjust the taxes for the prior year and will be used as an estimate. Paragraph 9D, special assessments by a public body. And in block capitals, it should say not an HOA or condo, but they chose to put it as the last line in 217 and 218. It's important to know that. It's an often made mistake. A special assessment is by a public body. It's very similar to the residential contract and designates what the seller will pay prior to and the buyer after closing. Make sure the buyer uses the due diligence period to ascertain if there are any and that the seller did not disclose them. To summarize, the seller will pay all dues ratified before close in full. If they may be paid in installments, the buyer and seller can agree to pay the installments up to close by the seller and then after by the buyer. Paragraph 9E is the disclosure summary for taxes. It's the same warning as residential. Don't rely on seller's current taxes to calculate the buyer's potential liability. Paragraph 10F is the FERPTA warning that the seller may have to pay additional funds at closing if they're not a citizen or a green card holder. Very similar to the warning in the residential contract. 10G, the 1031 exchange language, it says there's a statement of cooperation, basically. The seller will cooperate by executing documents to assist in a 1031 exchange. And paragraph 11 we've already handled. So we go straight, and paragraph 11, if you recall, was the computation of time. And we go straight to paragraph 12, risk of loss and eminent domain. So if the property or part of the property suffers a casualty loss, that means an insurable event. Trees blown down, for example, or a wildfire. Or if the property or part of the property becomes subject to a government action of eminent domain, where the government take the property in exchange for money, maybe to widen a road or to build a bypass. Seller will promptly inform the buyer in writing, and either party may terminate the contract and the buyer's deposit will be returned. If there's no cancellation, the buyer's going to accept the property and will receive any and all payments from an insurance company or a government agency after closing. Paragraph 13, force majeure. Seller and buyer will not be required to perform any obligation or be liable for non-performance of an obligation due to a force majeure event as defined in the contract. If it extends more than 30 days, either party may terminate and the deposit goes to the buyer. And they define force majeure as hurricanes, earthquakes, flood, fire, unusual transportation delays, wars, insurrections, and then any other cause not reasonably within the control of seller or buyer, and the non-performing party is not easily able to overcome with due diligence. All time periods extending while it is in force. Paragraph 14, notices. All notices will be in writing and delivered by mail, electronic means, or personal delivery. A buyer who fails to deliver notice regarding any contingency will proceed as if the contingency did not exist. The terms buyer or seller extend to their broker and or attorney. So in practical terms, when a notice is required by a seller, as long as the agent makes it, seller's agent makes it, then the notice has been deemed to be sent. Again, very, very similar to the residential contract. In paragraph 15, this talks about a complete agreement that persons are bound by this agreement. And it states that any prior agreement on the terms will not be binding unless documented in this actual contract. For example, if the seller tells the buyer that the land will be planted with grass prior to closing in an email during negotiations, to be binding, it must be included as a term of the contract. This paragraph also allows electronic signatures and then restates the common thread in Florida Realtors contracts that handwritten or typed terms are always going to prevail over printed terms. This contract shall not be part of the public records, as stated here, and the contract is binding on the heirs, administrators, executors, assigns, or personal representatives of the seller, buyer, and their brokers. Paragraph 16, default and dispute resolution. This paragraph survives closing. Seller default. The buyer may elect to be refunded their deposit without waiving any action against the seller, such as specific performance or damages. The seller will also be liable for the full amount of the brokerage fee if they default. If the buyer defaults, the seller may recover escrow as liquidated damages or sue the buyer. In paragraph 17, attorney's fees. In any permitted litigation, the prevailing party will be able to recover costs and fees from the non-prevailing party, including reasonable attorney's fees. Paragraph 18, escrow agent and closing agent. It's now a good time to remind you that the persons named on page 1 of the contract and the residential contract is the escrow agent, not the closing agent. They are often one and the same, but there is nothing stopping the parties from agreeing to hold escrow in one place and close at another. This paragraph authorizes the escrow agent and the closing agent to manage the funds. The terms collected and collection are defined as received and deposited in the escrow or closing agent's account. The paragraph also allows the escrow agent to interplead any case involving the funds and recover costs. Paragraph 19, professional advice and broker liability. Again, very, very similar to the residential contracts. The parties are warned to verify facts, consult professionals, check out the laws, check out the title, adhere to FERPTA, make sure they understand this contract, and don't rely on recommendation of vendors from the brokers. It's interesting that for the purposes of paragraph 19, the broker is a party to the contract and just this paragraph only, and it survives closing as well. Paragraph 20 talks about the Commercial Real Estate Commission Lien Act, which you may remember from pre- and post-licensing classes. If the property is commercial, the broker can place a lien on the proceeds of the sale in commercial transactions only for non-payment of commissions earned. Remember, we cannot use a lien process to recover commissions in a residential transaction. Paragraph 21 names the brokers And the difference between the residential contract and this one is that the agent's license number, email, addresses, and phone numbers are required. And obviously you would use your brokerage address on line 339. Paragraph 22, only 3 addenda for this contract. Obviously there's a box for other, and anything could be used there. But backup contract and kick-out clauses are the pre-printed ones. Paragraph 23 is the additional terms, where you would put some language maybe about closing costs, always a warning not to practice law, and start writing legal documents. Get advice if you feel the need to fill anything out in paragraph 23. Paragraph 23 also has boxes for counter offers and rejection at line 362 and 364. Spaces for the parties' signatures. And then you'll notice at line 381 that there is an effective date of the contract, which can be written in that box. That's much unlike the residential contract, which is silent on when the effective date is. So that's the contract.